Welcome to The Explainer. Today, we're tackling a situation that is, frankly, infuriating and way too common. You pull off a huge win at work, and your reward is to be pushed aside. We're going to break down your legal rights in India and give you a clear, practical roadmap for what to do next.
So, picture it. You just spent weeks, maybe months, pouring everything into a project. You delivered big time, and you're waiting for that well-deserved praise, maybe even a promotion, but then, nothing. In fact, worse than nothing. A new person is hired and suddenly they're running your show. It feels deeply unfair, right? Well, it might be more than just unfair. It could actually be illegal.
Look, we all start a job with a certain path in mind, right? You work hard, you get results, and you move up. It's a simple, logical progression. But suddenly you find yourself on this other path, a bizarre, upside-down world where your biggest successes are immediately followed by having your job hollowed out from the inside. This isn't just a bump in the road, it's something the law has a specific name for.
What you're going through is way more than just a personal grievance or a bad management situation. It actually has a legal identity. And under Indian labor law, that identity gives you very specific rights. So let's dive into what those are.
The legal term for this whole mess is constructive demotion. Think of it this way. On paper, everything looks fine. Your job title is the same, your salary hasn't been cut, but in reality and substance, your job has been gutted. The authority, the core responsibilities, the very essence of your role, it's all been taken away. It is, for all intents and purposes, a demotion in everything but name.
Okay, so to really get why this is such a big deal legally, we need to take a quick step back and look at the whole idea of the power balance in the workplace. This is kind of the foundation for all employee rights.
For a long time, the main tool for balancing that power has been collective bargaining. It's basically the idea of power in numbers. Employees, often through a union, band together to negotiate as a single, powerful voice. It stops the employer from just making whatever decisions they want whenever they want.
And hey, don't just take my word for it. The Supreme Court of India itself has weighed in, calling it a technique for solving problems through agreement, not through force or coercion. This core principle of fairness is the bedrock for all the legal protections we're about to unpack.
All right, enough with the theory. Let's get down to the nitty-gritty. Let's open up the legal toolkit you can actually use to call out what's happening to you for what it is.
Now, pay close attention, because your entire legal strategy, every protection we talk about from here on out, it all hangs on the answer to one single, absolutely critical question.
And that question is, are you a workman under the Industrial Disputes Act of 1947? Now forget your fancy job title. It doesn't matter if you're a senior analyst or a lead engineer. What matters is the primary nature of your actual day-to-day work. Are you mainly executing technical or clerical tasks? Or are you mainly a manager with real power to hire, fire, or discipline people? Answering that honestly is your first and most important step.
Why is this one word so important? Because honestly, the implication here is massive. Being classified as a workman is like having a key. It unlocks a whole different set of powerful legal protections specifically designed to shield you from exactly this kind of arbitrary, unfair treatment.
Now let's get even more specific. The law isn't vague about this stuff. It doesn't just say don't be unfair. It has a very specific list of actions called unfair labor practices, or ULPs. By identifying your manager's actions as a ULP, you're taking your complaint from "this feels wrong" to "you are breaking a specific law."
And this is where it gets really powerful. Just look at how your real-world experiences map directly onto the legal code. Your manager fawning over the new hire while ignoring you? The law calls that favoritism. That new hire suddenly taking over your project for no good reason? That could be an action not in good faith. And being sidelined right after you delivered a huge success? The law has a very clear word for that: victimization. And if you fall into that workman category, you get another major piece of armor. It's called Section 9A of the Act, and you can think of it as a powerful shield that protects you from sudden, negative changes to your job.
So what's the deal with the shield? Well, it comes with a number, 21. Your employer is legally required to give you 21 days' notice before they make any major negative change to your job conditions. They can't just strip you of your responsibilities overnight. And if they do, well, that change can be considered legally void from the very start. Okay, knowing your rights is one thing, and it's a huge thing. But how do you actually use them? How do you go from knowing you've been wronged to actually doing something about it?
Let's walk through the practical, step-by-step roadmap.
But before we take a single step, you have to absorb this crucial legal reality. The courts have been very clear. The burden of proof is on you. The responsibility to prove that you were victimized, to prove your case, rests entirely on your shoulders. Just saying it happened isn't enough.
So what does that mean in practice? It means that the second you get a whiff that something is wrong, you need to become a detective. You start discreetly collecting everything: emails, chat logs, task assignments. Dig up your appointment letter and old performance reviews, and critically, start keeping a detailed private log: dates, times, what was said, who was there. Document everything.
Now, your path to getting this fixed usually follows a clear 4-step process. You start inside the company, raising a formal grievance over email to create a paper trail. If that gets you nowhere, the next step is a formal legal notice from a lawyer. Often, that's enough to bring the company to the table for conciliation, which is basically a mediated settlement talk. And only if all of that fails does the whole thing move to a court for a final binding decision.
We have covered a ton of ground here, so let's just boil it all down to the absolute essentials. If you're watching this and thinking, hey, this is happening to me, what are the key things you need to remember? Here's your immediate action plan. Number 1, document everything, starting today. 2, go find your appointment letter and any company policies you have. 3, be brutally honest with yourself and analyze your daily tasks to figure out if you fit the workman definition. And 4, and I cannot possibly stress this enough, do not resign in a fit of frustration. Quitting can be seen as a voluntary act, and it could completely torpedo your entire legal case.
And this whole situation really leads us to a final, bigger question, doesn't it? It forces us to think about the difference between a workplace that is truly fair and one that is just legally compliant. Is an environment that pushes you to the absolute edge, forcing you to learn labor law just to be treated with respect, really a good place to be? Knowing your rights is about more than winning a legal fight. It's about empowering yourself to demand genuine fairness.